She hit me with overwhelming, I was kind of, maybe uncertain, I'm uncertain. I want the first one to be big. I just didn't have
Okay, that's good.
You gotta do that.
No, I don't see one.
So how have you felt about
I kind of maintain absolutely not man on a job. Going on the way.
Okay.
You're going to get buying the books, go to the 4,000 names. What about all these things? I knew it. So it's good to play it. Barry?
How you doing?
See you.
Good, good. You think we'll go 5?
Oh, I don't expect we will.
Down here. We don't. I've got some paperwork I need to get done. Some reimbursements.
Consider the most common thing.
Had to take that trip out to Reno.
See how you doing?
That was a bit expensive.
For
Civil Air Patrol had the conference on the legislative license. So I had to go out there.
how county's doing today?
Counties are doing great.
Great.
And y'all are helping us do that. Mr. Loudman, how you doing?
Good.
Good to see you again. Jim Kimbrough with ACCG.
Yes.
Mr. Brooks, what's the word, sir? How you been this summer?
Good to see you, man.
Yeah, likewise.
Well,
likewise.
keep it on the beach.
I'm trying to keep it like you now. Trying to keep it like you. Good to
see you, man.
Good to see you too.
Sir.
How you doing? Good to see you.
You having a good summer?
Oh, busy.
How you doing?
Not bad. How about you?
How you doing, Dan?
Yeah, how are
See
you?
you.
What's going on?
Just keep it between the lines this summer, trying to earn a living when we can.
I'm telling you.
I see him in the darndest places.
Really?
Partying in Ackworth, shooting fireworks.
Oh, they're legal now. You're the
It was an official event.
Well, it's like I told Judy Mann. I said, Judy, you guys are going home about this. I told the mayor, fire chief, I said, you guys make enough stink about this. I'm coming with the fireworks omnibus bill next year. We're going to have everything.
I should get you some of the fireworks shots. I got a lot of great shots of the fireworks over there. Yeah, I've got them for 2 years, but this year's were pretty good.
Well, I grew up in South Carolina, so I come from fireworks. I was 7 years old shooting bottle rockets.
Well, all my family's from Walhalla.
Still in the universe, right?
Yeah, and so that's what we would do. We'd go visit.
You
Is stop
shoot bottle rockets.
fireworks and go to my uncle's backyard and shoot fireworks. I mean, that was a treat.
You would love this. My brother is a pharmacist, and brother-in-law is a pharmacist. They're into this Pyrotechnic International Guild, which they have. It's like an international pyrotechnic where you learn how to do this stuff. They learn how to make this stuff. They come home with some real interesting ideas. You talk about pop bottle rockets. When they shoot them, they shoot 10 to 20,000 at once.
Very glad to help him.
Unbelievable.
In fact, this year they broke the world record for the most firecrackers shot at one time.
Unfortunately, that's a felony now under the governor's new litter bill, so you've got to look at
But it's like 10. They shot
chastised endlessly.
just under 12 million firecrackers. And for the size of crackers that you and I can buy, it'd be equivalent to 50 or 60 million. That's on this thing called a super strain. It's unbelievable. Definitely. Anyway,
That litter bill came through this committee.
Oh, yeah.
Chastised endlessly for, oh, we don't like that. And, Kevin Perry, he's not a friend of yours.
He's a physician and metabolic screening.
I'll get you a couple of those shots if you like.
Love to.
8 by 10s or 5 by 6.
Oh, whatever. Yeah, gotcha.
Oh, yeah, we Emory doctors like that. I forgot, there's a doctor who I work with on that.
Is Calvin happy?
Yeah.
Calvin was touching up, and apparently Jan says he's coming, so we're going to wait.
I'm talking about representing Mansville. The state, when the state lab identifies the problem with the newborn,
Get something from the
they'll
DOT.
send it to do the follow-up with the parents and everything. And Linda will make it. Jennifer contacted me, and I've got Dr. Steve next month. Especially now that the DNA.
Well, you know, what we want to do is we want to focus in. What I'd like to talk to them.
I just asked Jennifer, would you like to me to arrange something, okay?
Whether it's face to face or on the phone, and just taking our calls. Great depth on our range, but that broad.
And you can probably, you can zoom in, okay, on this that when he's not seeing patients and we do
Put the resolution.
I did.
Resolution. I think that kind of gives them a picture of where we're going, what we're looking to do. And then just having that kind of come into there.
You want me to follow with Jennifer to set something, or Jill would direct with you for a one-on-one?
We'll work each other.
Okay, I'll do that. Thank you.
And she can find me anytime. That's the hard thing.
I got some of those people too.
I answer her phone calls, so.
Well, we all do. She's kind of yeah. You just couldn't get it set up. It's calendar change. We'll get it set up before the 27th. Thank you. Thank you, Jennifer.
Well, Mr. Chairman, how are you? Well, yeah, I am here. This is legal independent I was talking about
Nice to meet you.
Okay. Okay, yeah, I'll come back during lunch. I'm sure
No. This is Tish, ma'am.
That's yeah. Super, you guys welcome to sit back. We'll get a chance. The agenda goes to talk about it.
Wait, if something motivates me, I'll let you know.
As you always do, right?
Hey, Mary.
Yes, ma'am.
This is Tish, ma'am. That's what I'm saying. We need to talk today. Yes, I'm in an internship. I'm in an internship process. I finished last Friday. We're just
No, they move a lot faster.
Hey guys, we're waiting on two committee members that are kind of caught up, looking to get here. As soon as we get everyone here, we'll get started. So.
You would send it back.
Well, it's that way.
Even down here.
There's like, I don't know if that's will be great. We should try it. Otherwise, I can even call it.
Sort of imagine when you goes way soon.
It's only 90 miles.
Because I honestly am not.
Oh, I can almost.
Oh, okay.
I can do it. It's not long. I was wondering about time and setting it up. It's really good.
I think it'd be fine if we just took a couple minutes before your vacation, unless there's a break. But he's kind of said he wants to sit there and like even through lunch. So it's really just gonna be a couple of quick pieces. But I'm gonna lunch is Friday.
Studious there.
Just reading.
By the way, forgot. Okay. I get home and I pop open this photo magazine. Take it off the top. Yeah. There's a whole thing. Privacy photography. I really think it's really interesting. It means actually the abuse that photographers are getting because of all the new crackdown. Yeah. I'm getting calculated. Okay. That'd be interesting. Whole other side. Yeah. Because I know you were talking about something similar. Yeah. Yeah, it's, this is going to be interesting to see, especially, when you start really, you've got to be smart, you've got to be proactive, you've got to be smart. Oh, yeah. You got national security, but you got constitutional rights. Yeah, you got to be careful what you ask for. You've got to find that alley. Representative Ed Setzler from
We may need to turn some of the other mics off.
Okay. Let's power these down when we're not talking. This one's on too. Again, on behalf of the House Study Committee for Bioprivacy, I'm the chairman of the committee, Representative Ed Setzler from North Cobb County. I want to thank all of you for being here today. I apologize for our late start. We have a committee member who's not going to be here today who was kind of touch and go with a medical condition with his mom, his elderly mom. And Representative Calvin Hill won't make it, so we were trying to accommodate his needs. That being said, I'd like to go around and have everyone in the room introduce themselves. My goal is to address the issues we have before us today adequately, but not exhaustingly. If we can finish early, we will. If we can't, we won't. But I think there's a lot on the table today, issue-wise, that's of interest to the committee that I want to make sure we address adequately so that the state can have addressed them and looked at them adequately moving forward with some policy concerns. That being said, again, for everybody's interest, the Biological Privacy Study Committee was initiated last session with House Resolution 1558, which in essence was created to look at the issue of indelible biological information. That's information about each of us, from fingerprints to photographs to DNA to a whole number of ways that biological information can be captured and maintained. And to look at a number of contexts in which it's maintained and made available to make policy decisions or to consider policy decisions to ensure that the values of the people of Georgia are reflected in Georgia law. You look at biological information and you consider what are the uses of it, from law enforcement context to identification purposes to medical information to tracking and ID verification. There's a number of technologies available that can use it and use it in a very profound and useful way. We want to make sure that the uses that are important for us and appropriate for us as a community to use are made available to us and are able to be expanded upon, but that the uses that might be inappropriate in terms of striking an unhealthy balance between individual rights versus the rights of the state or the rights of private institutions, that a balance be struck to make sure that we're staying where the folks of Georgia would want us to be as a state. So that's really the inspiration of the study committee and while we're here. And to that point, I'd like to introduce Representative Sharon Cooper, Cobb County. She's a member of the committee. Representative Barry Loudermilk, Representative Tyrone Brooks, myself, and again, absent today is Representative Calvin Hill. To that, I'd like to go around the room briefly and have everyone stand up and introduce themselves so we know who's in the room. As we move forward today, it's going to be a fairly informal setting, much more of a subcommittee kind of feel. We'll have speakers up. They'll have an allotted amount of time to talk and present. But if there are questions from the committee, I'd like to be able to stop folks as we go. And if there are answers from the audience that can shed light on the issue, I'd like to be able to recognize folks to do that. So don't be bashful about raising your hand. If a question comes up that you think you can entertain and speak to in an important way, be sure to raise your hand so we can do that. That being said, I'd like to start with Jennifer and go around the room and have introductions.
I'm Jennifer Cooper. I'm working as a research analyst for Representative Setzler. Anyways, that's all I have, and Jennifer's for work.
I'm Vernon Keenan, the director of the Georgia Bureau of Investigation.
I'm Delana with Emory University.
Bob Schmidt, I'm with UCB and Government Affairs Department.
I'm Tish Bell, I'm just a concerned citizen.
I'm Sue Allen-Dadweiler, volunteer lobbyist and newsletter reporter, which I'm very interested in this. Thank you.
I'm Pete Donaldson on behalf of the Georgia Criminal Defense Lawyers Association.
I'm Misty Haskins, partners with Mr. Dawson.
I'm Kim Kimbrough, Assistant General Counsel for the Association of County Commissioners.
Mike Wilkie, Chief of Police for the City of Ackworth and representing the Georgia Police Chiefs Association.
Bob Keller, I'm the Executive Counsel for the Prosecuting Attorneys Council.
I'm Ann Thompson, I'm a legal attorney, prosecuting attorney's counsel.
John Banky with the Georgia Bureau of Investigation.
Staples, GBI Crime Lab, DNA Unit.
I'm Maggie Garrett, I'm with the ACLU of Georgia. Amy Maxwell, Georgia Innocence Project.
Sandra Michaels, lobbyist for GACDL.
Rick Russell from the Legislative Council's office.
Appreciate you guys being here very much. Again, I want to make sure we use our time wisely today. We are going to be working through lunch. Gactel has graciously provided us lunch today. I think we've got plenty of lunches for all the folks here. So if you plan on staying through, there should be enough to feed all the mouths we've got. So again, we'd like to push through, and we'll take periodic breaks as necessary. But to that point, I want to walk us through briefly the agenda before we get started. Again, Jennifer, have you made these available to all the folks?
Actually, pass them out.
Okay, got a couple extra versions here. Okay. We've got an agenda for today's meeting, and we have a draft agenda for the September 27th meeting. We're going to have two testimony-driven meetings of the study committee. Today is the first. Our first meeting was just an organizational meeting. Today is the first real meeting where we're taking testimony and having discussion. Today's focus is on biological information in law enforcement contexts. On September 27th, we'll have our second meeting, which is really looking at the other contexts, from insurance to medical practice to personal identification, business use, research and development, and so forth. So the agendas for today and the draft agenda for next meeting are provided to you. That being said, are there any questions before we get started from anyone in the committee or anyone in the audience about how we'll be moving forward today? Hearing none, I'd like to recognize, on behalf of the Georgia Prosecuting Attorneys Council, we've got Bob Keller today. Bob, are you going to be making the presentation?
Yes.
Okay. Bob, if you could, please.
I'll ask Ann if she would just come up and if there's anything. Ladies and gentlemen, I want to thank you on behalf of the Prosecuting Attorneys Council of Georgia, which represents the district attorneys and solicitors of the state, for the privilege of being here. One thing you understand and learn quickly as you get older is that you rely on young minds and young talent to do some of the real work when it comes to researching things. And I want to commend Ann for some of the work that she did in getting us prepared, or attempting to get us prepared to make this presentation and everything, and I thank you for it. I'll be very candid with the study committee. When we got the notice or the invitation to speak, I hadn't thought much about the subject of this. I had not given it much thought. It's something that was just not on my radar screen, and so obviously trying to be prepared, I learned a little bit more about why the study committee was formed, and I would just want to go ahead and tell you how much I appreciate what you're attempting to do. This is a huge issue, and I hate to act ignorant about it, but I realize with some of the things that are happening on the national level, with the talk of national ID cards, with the talk of about how to combat terrorism and what the government should or should not do, that this is an issue that is going to affect all of us. And it's always refreshing to know that Georgia is not going to sit by and take a back seat, but that Georgia, through a study committee like this and through our legislature, will do what is necessary, not only to protect society, but to protect individual rights. And so when we start talking about this situation and we start looking at the concerns, I want to emphasize that the Prosecuting Attorneys Council, the prosecution community, is very aware of the necessity for balance. This is not a situation where we want to be part of a big brother. We're going to look after you, and we're going to invade you under the guise of protecting. If we protect society to the detriment of individuals, then we have not done what we need to do. And so you are not going to hear from prosecutors that we are going to be opposed to legislation that strikes that balance. Now, the dilemma, and I've been doing this so long, that the first thing that you do when you have a study committee, you want to know what they're going to do. First thing you want to know is, all right, what you planning? You know, let me look at your proposed legislation, and then I'll give you an opinion as to what is our position on this. Well, obviously, that's what the study committee is designed to do. What do we need to do? What are you looking at? Are there gaps in the current law? Futuristically, where are we going with the technology and the advances that we've got in the gathering of that information? And then based on that, then of course that's when the legislation comes. So in an attempt to basically talk in terms of a prosecution position, it's a little difficult to articulate with specificity exactly how we feel about certain things, but I'll attempt to just sort of go through some of the things that we've got. When you talk about the concept of ID cards with biometric identifiers on it, that certainly creates some fear when we're talking about stuff like that, because it basically means, and I'll steal a phrase from Pete, who is going to speak a little bit later, when he said he can see you getting stopped, and the next thing the police officer says is, give me your information, give me your papers, and the next thing you know, he reads off a little card and it says everything about me. You know, that weight that hadn't been right in 15 years, the height that, you know, used to be right 15 years ago, but now has, you know, decreased a couple of inches with time, and then who knows what else. And that's, yes, indeed, I have. We know all about you, and so. But if you look at how Georgia is moving in this area, Georgia's moving away from this. Up until 2005, we had the fingerprint on driver's license, and this legislature decided that we would not do that. Yes, I know exactly how that came about. But my point is, so you know, in Georgia right now, Georgia's reaction to that through its legislative has been to back away from that. So we do not have the ID identifier situation that we've got in Georgia. Now, the biggest thing that we've got are the biometric database that we've got in Georgia, and I'm not going to talk about this in a lot of detail, because after speaking with the GBI, they are better equipped to address that, but is our DNA database, and that's what we've got. And for those of you that recall, we had a situation now that the legislature through statute has, we require convicted felons who are incarcerated to give up a DNA sample. So if you're going into the Georgia prison system, you are going to give a DNA sample. The constitutionality of this has been ruled on. It was ruled on in 1997, and it basically said that the Court of Appeals of Georgia upheld the constitutionality of the statute, saying that this was a situation that did there were no constitutional violations when you're dealing with this. I mean, we're talking about a convicted person. We have another interesting. Yeah, yes, sir.
Just a question about the database you were talking about with the convicted person. Is that felons and for misdemeanors?
No, just felons.
Just for felons.
Just felons.
Okay.
And just felons, Representative, that are incorporated.
Okay.
So in other words, if I, for instance, get, and this is a good point, and this is getting to, and this is a policy issue that this committee will have to address, and that is, and I'll get into it just a little bit longer. Do we need to expand that, and where do you, and if you expand it, how far do you go? But right now,
so I'm sorry, just to clarify. So currently, if you're convicted of a felony and incarcerated, DNA is taken, but if you're convicted and some other diversion happens short of incarceration, they don't collect.
That's correct.
Okay.
That's correct. Now, And there are, and I'm just going to sort of move through this, there are protections that are set up in the statute about the accessibility of this database, who can get it, who can't get it, how it's protected, and it is pretty well protected in that sense. We have another database or another gathering of information, and this is as a result of some things that occurred, and it really grew out of, and I don't know whether Amy is going to testify or not, but if Amy Maxwell, who is I know here with the Georgia Innocence Project, came out of some of the cases that involved people who were subsequently found innocent after incarceration. And I happen to have one in my circuit in 1983. We convicted Calvin Johnson of a rape. And it was a horrific crime, and it involved the use of a similar transaction. It involved the use of, to the extent that you can call it eyewitness identification. There was some identification. Unfortunately, this is not a situation of eyeball to eyeball facial identification, because the perpetrator of this crime did not show his face, and so the victim could only talk in terms of appearance, voice, and other things of that nature. There was a conviction and a life sentence, and there was no DNA. This was back when there was no DNA, and so this was just a crime. I mean, it was just a situation where you had 12 members of a jury, and they found guilt beyond a reasonable doubt, and then you had a sentence. The entire time, Calvin Johnson's maintained his innocence, and this is not out of the ordinary. A lot of times defendants maintain their innocence even after conviction, and rightly so. However, in 1992, there was an interesting situation that occurred in Clayton County, and that was a judge had retired. A new judge was coming in, and a court reporter was no longer going to be the court reporter, and this was the court reporter that had handled this case. And back in those days, court reporters maintained evidence of cases, and so I sent some investigators up to the court reporter's office to see if there was any evidence that we needed to keep. And in a waste can were some evidence from the Calvin Johnson case. And they called down and said, "Hey, Bob, you want us to keep this?" Now, I would love to tell you that I had a crystal ball. I would love to tell you that there was a logical basis of keeping it. I'd love to tell you there was a legal basis of keeping it. There was none. We will not get into a religious discussion, but I happen to believe in miracles, and if you do also, this is a miracle. And there was, this is 1992, this is 9 years after the conviction, and for whatever reason, I told them, sure, bring it up to our evidence. The rest is history. 5 years later, we got a call from the Innocence Project that wanted to know, do we have the DNA? Yes, we do. I mean, we've got samples. Well, could you consent to a DNA test? Yes, we did. The DNA proved it was not Calvin Johnson. The charges were dismissed. He was released. He, along with some other excellent advocates, formed the Georgia Innocence Project. Amy is the chairman of that, and then we worked with legislation that talks about the preservation of possible DNA evidence when there is not a perpetrator. There is a horrific crime. The police officers go to the crime scene, and under the Georgia statute now, they're required to gather evidence that would be potentially produce DNA that would lead to an identification of a perpetrator if there was ever a perpetrator caught. And I won't go into what the statute says you keep, but if there's a way to test it, then there is a retention situation. Now, from a privacy standpoint, and from a situation of an invasion of the, and when you look at a balancing here, we've got a society protection issue versus have we violated anyone's rights? Well, we don't know who this person is. We don't know if this person will ever be identified. So in that situation, you look at our database or this collectible evidence that could initially produce something, and you see that that is something where the protection of society outweighs, any type of invasion, because no one's been invaded. This is evidence that's left at a crime scene. This is not anything that was required of someone to produce, on their own thing. So that is another database that we have that or potentially that we've got. We've got the fingerprint situation about when you can fingerprint, when you can't fingerprint. The GBI is going to address that and everything. If you move down, the line, so to speak, you can look at other things that could potentially be invasive, and we talk about video surveillance. Where, you've got statute protections now about video cameras in private areas where there's an expectation of privacy. That's prohibited. Cameras in public areas where there is no expectation of privacy gets into a different, an area about how can there be public backlash, and depending on where those cameras are, there could be, and then that's a balancing of a government right, like your tickets are, the camera as you go through the intersection versus the camera that is in front of the ATM window that you got. Yes, sir.
Could you speak to that for me? The expectation of privacy, where you draw the line, and what kinds of areas can surveillance go on? Just general surveillance without a warrant, but just general looking, and how that can be used, and what's admissible, what's not admissible. Things.
Well, gosh, dog, and I will call on my colleagues that are back there to correct me if I am wrong on this. But let's talk about a bathroom, for instance. You can't. If I go into a stall, I have an expectation of privacy, and so I don't expect to see a camera in there, monitoring, my every move. You've got an expectation of privacy in a phone booth as it becomes to an eavesdropping situation. However, if I go to a public place, then there is not an expectation of privacy because I am out in the open. If it can be viewed by other people, it could be captured on camera. And so if I take any attempt, and I don't mean an attempt to hide in a public place, but if there is anything that is restricting access in where my location, for instance, like the bathroom, like the phone booth, that is away from public view, then you get into the situation about how can you get into that? Can there be a camera there, or can there not? And then you've got the interest of the public. We had a situation that we just heard about that occurred. A new restaurant opened, and the new restaurant wanted to know what the waitresses thought about the ownership. So they put a hidden microphone at a waitress station to capture the conversation of the waitresses, and they were monitoring what the waitresses were saying about the cooks and what the waitresses were saying about the owners and everything like that. That is a definite no-no. There was no way that there was not an expectation of privacy. If we were having this conversation, if Representative Cooper and I were having this conversation outside the public and everything, but we were standing at a place, that there was a hidden mic. So that would be an example where you would not have that. The different cameras with the law enforcement, with the speeding and everything, where there, you run that, you have what I always like to call is the rolling stop, and that is there's no reason to stop completely, especially at night when you can see both things coming. Well, the camera captures me, and I did not make a complete stop. Is that invasion of my privacy? Well, I'm out in the open. I'm clearly in the public eye, and so that has not been something that has been, I don't like it. I don't like Big Brother looking at me and taking my picture when I'm violating the law. How dare they do that? But here again, I was right out there, in the public view.
I have a question that was dealing with being out in public, but being in your automobile. Has the courts or anyone looked at, are you expected to have an expectation of privacy while you're actually enclosed in your automobile, even though your automobile might be out in public.
Well, here again now, there is an expectation of privacy as to what the law enforcement officer can do as it relates to your automobile. In other words, a law enforcement officer just stops me, and a law enforcement officer says, "Mr. Keller, you were speeding. Let me give you your driver's license." Well, the expectation of privacy to my automobile is, unless there is some type of probable cause, law enforcement can't invade my vehicle. So that's, if you want to put it in a privacy situation, you should have an expectation of privacy unless there is something that comes to law enforcement's attention. You can have plain view. He looks in there, and for anyone to see who is in his position, there is, drugs, which then puts it in a different issue. But there is a, let me put it this way, there's more of a constitutional protection against an unauthorized search without probable cause, which would, I think, you could equate into an expectation of privacy.
But when we're, I'm sorry.
Go ahead.
But when we're talking about photo enforcement of traffic violations, we're not really talking about the expectation of privacy that would exist within the vehicle, because you're watching like the movement of the vehicle itself, which is readily observable, not as opposed to looking at something that's being done inside the vehicle.
And that answered the question I was going to ask, is dealing with well, let's go beyond the traffic cameras, because I know in Georgia, I believe that it's that we have that in code that the camera can't take a picture of the occupant, that it's just taking a picture of the vehicle license plate or its position in the intersection. But what about other surveillance cameras? Is that ever been addressed? Is there an expectation of privacy in your vehicle from other type of surveillance, or do the cameras are just looking at your vehicle?
I'm trying to think if we have cameras that would even do that. The only cameras that I can think about would be ATM cameras that would capture a location, and by virtue of that location, if your vehicle came within that location, it would then could conceivably capture something there. But that's the only thing I can't think of. I can't think of a thing where a camera would be doing anything within the vehicle.
And to your question, again,
thank you.
We're going to be addressing video identification in public access space in the September meeting. Where it applies to law enforcement contexts, particularly where you've got facial recognition technology that's saying, hey, we're monitoring an intersection, and this guy who we've been looking for drove through this intersection. We caught his face through visual recognition, and it matched some data. That would apply to a law enforcement application. So that would be on topic for today. The general public space discussion, I think we're going to have in September, and I'd like to maybe address that issue when you're about ready to wrap up, Mr. Keller, if we could.
Okay.
I just want to get back to that. I don't want to throw you off step.
But, you won't throw me off. The other thing that and this is more policy related, because we and I'm going to talk about DNA a little bit more, but when we start talking about the confidentiality of our DNA database, I think is pretty well statutorily grounded. I think we've got some safeguards. I think an area of concern would be in your private sector basis, and that is what information can a private sector gather, and then what happens to that database? And I think it's a situation, what do I have to give up in order to qualify for that loan? What do I have to give up in order to qualify for certain things? And then if I do, then what have I given up? Do I give it up just to that company? Or what kind of situation does that company, then have? What kind of responsibility does that company have? What kind of responsibility does that company have to other companies? What kind of responsibilities does that company have to governmental agencies? And we've got the situation, and I think this is something on a national level, dealing with phone records, and that is a situation where in the name of battling terrorism, I think Southern Bell South or those gave up phone records. Now, they did it through a consent. Now, one of the things that you're going to hear about with protections, when you talk in terms of protections, you're talking about your Fourth Amendment protections. And there are certain things that I can't get unless I have probable cause. However, I can get them if you voluntarily consent to giving them to me. Well, that is an individual situation. Chairman Sessler, I need such and such and such and such. Will you give it? Sure, Bob, I'll give it to you. Or, Bob, unless you've got some legal basis of getting it, you're not getting it. And then I have to, within the Fourth Amendment protections, come up with a basis of doing it. Well, what if Chairman Sessler gave to Bank of America this information, and I, as a governmental agency, go to Bank of America and I say, I want all the information on Chairman Sessler? Sure, we'll be more than happy to comply. What expectation of privacy does he have? Now, the problem is, it's one thing if you're saying, well, then it's a consent. It's a consent from that party to the government. And what standards should the government be held to in order to get it? Does the government need to have probable cause? Well, your first reaction would be, well, the government needs some basis of requesting it, and it needs to be more than consent. But then at the same time, let's suppose Bank of America and Wachovia get together, and they don't do anything. They decide, I'll give you mine, you give me yours. And so you've got a situation where two private entities commingle, and there is no security between those two privates. Yet if government needs it for governmental interests, they're held to a higher standard than private are held between private and private, if you understand what I'm saying. So what I would ask this commission to do, or this study committee to do, when you're looking at the protections, that we don't hold government to a higher standard than we hold the private sector to in this exchange of information. If we're going to protect the individual, that you protect the individual from other private sector concerns, as opposed to just protecting the individual from I would consider a governmental concern. Because and the one thing that when we were doing our research, you've got the probable cause expectations and the probable cause requirements, but when you're talking about that big old word called consent and agreement, if two private companies can enter into an agreement, we're going to give all of your information to you, all of your information to you, then you've got a whole, then what about the private person who said, I don't want Wachovia to have it. I gave it to Bank America, but I do not want Wachovia to have it. And then does the private individual have to give up anything in order for Bank America to even listen to that private individual? Or is it going to be a situation where if you want this loan, you will give us all of this, and we have the right to do to anything we want to do with that information? So here again, I have no solution to that. I just bring it up from a prosecution standpoint and a protection of society. Let's don't erode society's protection, if there is a situation where the individual is not being protected, in that private sector.
I'd like to revisit that hypothetical scenario that you just gave us, to where, so Bank of America, I believe, I've been told, I don't bank with Bank of America, but in some cases requires fingerprint to do business at some of the banks. If that information or other information or privacy information that you that the consumer has consented to give up that information to Bank of America, that consent is for them to give it to Bank of America, as you stated. In the situation to where that government then requests that information of me and I deny it, is it a legal process that you can then go and get that from Bank of America?
Well,
because the consent was given to the bank, not to the government. I mean,
well, that's the question. Can Bank of America consent to a government request versus does Bank of America make the government show a basis of asking for it? In other words, to the extent that we would show that we had probable cause going through a Fourth Amendment situation through a subpoena, in a legal process, or could we just do it under the color of consent? And that's the interesting question that comes up, and that's something I think is being debated right now on the national level, in the name of security. And I just bring it to your attention that is something that I think this committee would want to look at, and that is a balancing between what this individual has done with Bank of America, and then what can this individual expect from Bank of America to protect that information? And I don't have a good answer for you.
Well, a question you might have an answer for, legal counsel or someone else in the room, that has the courts, legislature, government ever identified who owns the data? Is that personal information about me, my data that I own, and I'm only giving access on a temporary basis to Bank of America? Therefore, if they release it, then that equates to theft, because it's something that they did not own that they are selling or giving to someone else. Has that ever been
I don't know that when we talk about the biotype information, most of the information from a Bank of America type situation are going to be it's a transactional situation that involves records and involves the non-personal aspect of it, as opposed to what you're asking. And quite candidly, I know of no case now here again I'll defer to anyone in the room if it has been established, and it might have been even established in a civil type scenario as opposed to criminal on that, and I just don't know that.
I know there's a Supreme Court decision years ago dealing with the fingerprint, is that the decision was, since there was just dealing with an arrest, not a conviction, if someone is suspected, that there was just cause in the fact that they were suspected, that law enforcement or the government could take that information, and part of that decision, whether it was actually spelled out in the decision or it left with the understanding that the fingerprint, that information does belong to the individual. And that might be something to think about with the committee, is the ownership of that privacy information.
Yeah, right now there's no, I couldn't find any statute that specifically addresses this situation, but that could be possibly one way to address it. But at the same time, we should keep in mind that there's no reason why law enforcement shouldn't be able to obtain this information when it's supported by probable cause and through the appropriate legal channels.
So that question, go ahead, Mr. Kelly.
No, what were you?
So if, in the context of this bank or this institution we're talking about, currently if they didn't consent, and I'm not clear that they could consent or could not consent, but if they were resistant to giving up this information, but law enforcement wanted it, under current law, through the subpoena process, it could be obtained.
That's correct.
Probable cause, subpoena, get the information. So but it would have to go through those channels and only in that context.
That's correct.
Okay. So the question we need to address is, do ownership of data, and can any biological information, and which could be enumerated in certain types, do private entities that have obtained that from folks have the ability to consent with that, or does that belong to the individual that provided it? That's the
question.
To make sure we frame that clearly.
And I think it's not just the type, but when you were in the military, I worked in intelligence. You take one piece of information, it might not be classified, but when you combine that with several other pieces of unclassified information, then that becomes dangerous material. It could be that name and address is not necessarily information that the person might be considered to own or dangerous, but when combined with social security number and other information, then you could be looking at a problem. So just my thought process as we're going is, we might say, well, yeah, when it comes to DNA, fingerprint, those facial features or whatever, that is owned by that person. I think we have to look beyond that, is at what point is information that is improperly released violate the privacy of that individual. But I appreciate your point dealing with the between businesses. We tend to hesitate to regulate industry as much as I believe the Founding Fathers intended us to regulate government more than we do the private industry in certain instances. But I think you bring up a very valid point in what could the transaction that could happen between two private institutions, and I think it's something we do have to take a look at.
Well, that's the one thing, and here again, and I was kidding, but I was also serious. I mean, this is a situation where just back in 1983, we never thought about DNA, and so now look at DNA with the advent of CSI and some of these shows. There's an expectation that there should be an identifying mark to solve every crime, and that it can be gotten off everything. I am amazed at some of the ways they get it on TV. I hadn't gotten them like that, but it's amazing how you can get it. But here again, no one thought about what now is demanded of individuals in our society from this bio situation, because we have become so technologically advanced. When you can go to a computer and type in a name of anything and Google it, they say, my goodness, what information highway is now available. So it is something that, like you say, I don't have the answer to, but it's something we really need to look at, and I commend this. Sort of to get back to the DNA and to get back to some of the things that I think this study committee will be looking at, and that is looking at the DNA database and whether or not there needs to be an expansion or not expansion. And at a situation, there are about 7 states now that authorize the collection of various categories of arrestees. California, Kansas, and Louisiana all have felony arrestees. Minnesota, New Mexico, Texas, and Virginia have other aspects of it, and then I think about 44 states deal with the collecting it from felons as it relates, the convicted aspects of it. Where does Georgia need to be in a situation like that? And if we look at a little sheet, and if you look at some of the categories that we've got, you've got arrest of a misdemeanor. That's something that is punishable by less than up to $1,000, up to 12 months in jail.
Mr. Keller?
Yes.
To that point, the other context, New Mexico, I think Texas and Virginia, you said?
Right.
What are any of those, what I'll call it, context shy of felony, or are they beyond felony, i.e. incarceration?
I think that these are, I think they're I think that, unfortunately, and I don't have I will get better data for you on this. I think some of these are felonies. I think some of these are in addition to felonies.
Okay.
I think with the various categories, there could be misdemeanors also involved.
And when you said, and again, you may not be able to speak to this immediately, but California, Kansas, Louisiana, are those arrest for felonies as a procedural thing? Are those convictions?
No, this is arrest. These 7 states have varying degrees of collection for the arrestee situation.
Okay.
So as soon as that person's arrested, no conviction, no anything, it's almost like we do fingerprints now.
It's a procedural thing, yeah.
It's a procedural situation. If you're booked into a jail, you are fingerprinted from an identification standpoint. So if you're booked in, or if you are arrested, and this would be different from the citation, where you're just ticketed and told to have a nice day and appear in court on your summons. But if you're actually arrested, then those 7 states have some degree, and I will get that for the committee.
And this is where I'll need you to educate me briefly, and maybe some members of the committee, on criminal procedure, which I'm still learning. I have a real steep learning curve still. From the stop, whether it's a traffic stop or you stop a car because you've got probable cause that there's drugs involved or whatever, all the way through, as you said, booking somebody in jail, unpacking that issue and focusing down within that. Where would the line be drawn from, okay, the cop stopped people, the cop took folks down to the station, say it took a group of 6 or 8 people down to the station, but upon further questioning, 3 or 4 people just weren't seen as being worthy of being charged. They were just released because after questioning them, it didn't seem they were related to the crime at all, and they were released. Is that were those folks that were then released? Would they consider to have been arrested,
Well,
or would a charge have to follow?
If you have a restriction of your freedom,
Okay.
then that's going to be a legal arrest.
Okay.
Now, we don't think of it in terms of, when we normally think in terms of arrest,
Okay.
we think in terms of somebody who is taken to a jail and booked in.
Right.
But for your legal constitutional protections, if I restrict your freedom, if you cannot leave, and I make you stay, then you are, quote, for those purposes, arrested.
Okay.
Now, for your criminal procedure purposes, what would normally happen is, and we've got a chief here, and he can verify this. But if one of his detectives, for instance, they stopped 6 people, and they, quote, arrested them in the sense that they took them to the station, and upon further questioning, 4 of those people were then told, you can leave. Then you will probably see their names in reports.
Blotter.
In the investigative report, because 2 of those people were then subsequently booked into the jail and arrested for the robbery. And the other 4 people that were questioned, their names are going to be contained in the report, and their degree of culpability is also going to be stated. But you're not going to see them from a fingerprint standpoint. They did not reach that. But they were, in the sense that their freedom was restricted, they were arrested from a legal standpoint.
Given that definition and given your understanding of what some of these states may be doing, I'm trying to get my mind around in that circumstance. The 6 folks that were brought down to the station, 4 were released, 2 were booked into jail. Would the 4 folks that were brought down to the station, having been placed under arrest, would they be subject to DNA being collected, fingerprints?
No, I'm using that arrest, unfortunately, just from a legal standpoint, to show that they would have certain things would have to be. For instance, if they were brought down and arrested, then there would be a requirement before they could be questioned that there would be rights advised. Certain that their status would trigger certain protections. But now, for your purposes of DNA, and for the purposes of these 7 states when it says arrestees, those arrestees are those that I would suspect are actually being booked into the jail. They are not convicted.
Would you call that charged? I'll recognize your question, but I don't know. I'm trying to find the term of art for, I'm taken down to the station, that's pre-charge.
I really think that you can almost use the term for the common understanding. The term arrest is what you would really use. That if you're arrested, because if I asked 10 people, what does it mean arrested? Man, they took me to jail. Anything that involves taking me to jail, they're going to say I was arrested. So I think I think if you use the term arrest, you're using it versus conviction, and I think that would be I don't think we need to get into the charged or not charged. I think arrest is going to be the better word for that.
Okay.
Well, not that I can ever modify something that Bob Keller would say, but hopefully shed a little light in the sense that our courts have embraced a distinction between a full custodial arrest versus a detention. And detention is seen as something that is somewhat shy of a formal charging decision by either the arresting officer or some prosecutor who either files an accusation or seeks some sort of indictment. So there is a distinction out there that is currently in the law between a detention, which may very well be an arresting of your freedom of movement, but you have not been formally charged, formally declared to be subject to probable cause and that sort of thing. That might be a little illuminating.
That's the distinction I'm looking for. Is there any information that is required to be given upon detention? I mean, for purposes of identification, for any purpose, do you relinquish any information at that point? I mean, do they take a photo of you? Do they take your prints? I mean, because again, I think about, and again, as you think through some potential hypotheticals, I can imagine being a guy serving in the military, whether he was on the street to his mom's house in Washington, D.C., and all of a sudden he was in the midst of a crime scene. There was a gang shooting. People were dead and bleeding right next to him. He ran and grabbed a guy and was caught up in the scene. Well, the cops came and detained a number of folks, brought them down to the station to begin to unpack what happened. He was detained. He was an innocent guy, and that was established. But would he have relinquished any information, having been an innocent bystander involved at a scene of a crime? And that's
very quickly, because I don't want to take up time here, but we have 40 or more years of history in this. If you look at organized crime investigations, photographs, matching up of names and faces, people who they associate with, activities they may or may not have been involved with. Here more contemporarily in the past 20 years, gang books, any person who, we have very comprehensive gang prosecution language in our code now that talks about persons who associate with one another, wear identifying colors or tattoos or other markings. And certainly there are officers, and this is commonplace practice, I think all of us are familiar with this, you see it on the television news, where officers out conducting field investigation, shy of a charging decision, but having identified individuals who fit that criteria, taking photographs, conducting third-tier citizen police officer encounters where they ask for information like your name, who you identify yourself with, and of course those individuals don't necessarily have to give that information because they are shy of an arrest, but to the extent that they proffer that information, it's going to be recorded, it's going to be put in a database, and they certainly will have their picture taken, may or may not be without, with their consent. It has to be compiled.
Just adding to what Kim says, I don't think it isn't going to involve fingerprinting. I think the most it will involve, other than the question answer. Let me see. Show me some identification, which would be producing a ID card, producing a driver's license, so that the person knows who that person is, and maybe the photograph that for purchase. But I don't know of anything where they would be doing without something else, without other probable cause, there would be any type of fingerprints or any other type of identifying it.
I want to recognize, did you still have something to add?
Well, Mr. Chairman, I just want to throw this out. You can tell there were only 7 states that were not doing this, and the reason that this is a fairly new allowance that was made under the DNA Fingerprint Act signed this year. It was just signed, I believe, January of '06 by President Bush, that would allow for collection of arrestees or those charged in indictment. It is still up to the state to come up with their own statutes on how to do that and how they plan to collect for that. Of course, funding also comes into play. That's why they're still only 7. Louisiana, I do know they have live scan instruments now in their booking station. So when someone comes in, the live scan fingerprint, that's checked, and if they're already in the system, they go back, and then when they're arrested, they collect the sample.
So again, I talk about casting a broad net. If on a crime scene a number of folks are brought down to the station for questioning, let's say that one of the 4 people, again, pre-arrest, I don't know if it's pre-charge, I don't know what the appropriate term is, if upon questioning they were found to really not have contributed to the crime and they were going to be released to the street, you're saying in Louisiana there's a back channel check that, having been booked into the station, you can look at other things that might be on the table that they could have committed, and by the fact that they were brought down to the station, found to be innocent in this circumstance, could be linked to something else via the database. That's the issue we're trying to get at is.
It would be up to that state to define whether or not to collect it.
Okay, and in that context, you're saying it's photometric, photo ID with fingerprint.
Live scan fingerprint, and then they're held, and then when they come back and that's confirmed that is the person.
Okay.
Then they'll make the sample.
Okay.
I'd like to just take this one step further, a question that I've had, and really two-part. I'd like to go back to Calvin Johnson's situation, but before that, let's take the scenario that Representative Setzler's laid out. Case, hypothetically, I'm arrested, taken in, booked. Our Constitution says I'm innocent until the jury returns and gives a guilty. If I'm correct in that.
That's
that
right.
I retain my innocence.
Or
plead guilty.
Your evidence,
right.
You plead guilty or found guilty. That's correct.
At any point from the point of arrest and I agree, information can, in most cases, should be taken. Constitutionally, the Supreme Court has ruled that we can do that. But if any point from the suspicion of the crime, the arrest, booking, up to the point the jury comes back and let's say the jury determines that I'm innocent, or at any point in there, innocence is determined, what is the retention of that data? And as a citizen that the Constitution has declared I'm innocent, do I not have a right to return to the equal station that I was in prior to my arrest?
Okay, now you have just hit the mother lode of controversy as to that. Right now, we're going to talk about expungement. Okay? We're going to talk about from an expungement of who else can get it. If you, prior to indictment, prior to anything, don't you just love somebody that is? This is your code section is 24-4-65, and talking about some of the expungement, and there's some other code sections that deal with just the expungement. If you are not charged, you can make application to have your record expunged, and then it goes through a process. The prosecutor signs off on it, and there is a situation then that the Sheriff's Department and GCIC, and I will let them tell you exactly what they do when they get an order of expungement. But there is a basis of expungement. There is no basis right now for a fact that you, and I had this situation where a person said, I am not guilty. We felt like there was sufficient probable cause to indict. The grand jury indicted. We felt like there was sufficient evidence to prosecute. The person went through a jury trial, and that person was found not guilty. Now, there was no basis to expunge that record. In other words, they went through. That was it. It did. Now, should there have been anything? And I was the prosecutor, and I was trying to figure out a legal way to do it, but the statute did not provide it. Because there was evidence that this was, there was not a mistake. The record, the person was arrested for theft. Mm-hmm. The record accurately showed an arrest for theft. The record accurately showed the disposition of the case, not guilty, by jury. So the record was correct. But from a standpoint of expungement and innocence and the right to, did that person have that right? And our statute doesn't provide it. While this is not a situation that really this study committee was designed for, our expungement statute needs to be looked at because there are some very big inequities in it, and I am telling you that from a prosecution standpoint.
I will say this: it is in the I think in the expectations of the committee in our first in our first organizing meeting, not to address expungement holistically, but address the issue of biological data maintained by business, maintained by government in any context.
That would get to.
And at what point, if it's handed over at some point, what are the circumstances in which it has to be purged and gotten rid of and so forth? So that would tie in.
The last thing that I just wanted to say, and I wanted to talk about, and I'll just be very brief, and then I'll see if that represents, get back to you, that question you might have had on that, is the DNA and where we're going. I don't know that if we look at the Georgia's history, Georgia's inclination, I don't think we're going to the ID card. I don't see that happening. I think you've got a balancing, however, from a fraudulent standpoint on how much you can collect and how much you should collect. I think you look very carefully, though, at our DNA bank, and I think you look at the benefits of having the collected the collected evidence from the convicted felon situation, and then you look at whether or not there is there a balancing of individuals versus the policy decision for the protection of our society, and then you look at what else you should collect. Now, we hear about what 7 states might be doing about arrestees. We still, in Georgia, are not even collecting it on convictions, on all convictions. We are not collecting it on convictions that do not involve incarceration. Now, when you look at it, and I will, the balancing is there a reason to do it? All, felonies involve a lot of non-violent acts. And do you need to collect DNA on theft by shoplifting? And that's a question. And so instead of saying all felony convictions, should it be all felony convictions that involve crimes against people? But that result in probation as opposed to incarceration. Those are policy decisions that this committee should, I think this study committee should look at. And you don't even in Georgia, there seems to be some middle ground before we even get to the pre-conviction aspect, which will be the more troublesome situations because it could involve the person, the retention of evidence against a person that has not even been found guilty. And so, since Georgia just does it on incarcerated felons and doesn't even do it on all felons that are convicted, you might want to look at that. You've also got convicted misdemeanors, and do you do it to all misdemeanors, or do you do it to those that are of a high and aggravated nature? Do you do it with those that here again involve something that deals with the potential of violence that could then affect the protection of society? If I am a repeat domestic violence batterer or thing, and I am convicted of several misdemeanors, should you collect my DNA as opposed to somebody that is a habitual speeder, that just keeps running that red light or keeps speeding? And is that, in balance in that? With that, let me just say that from a prosecution standpoint, we want to work with you. We again think this is now that I figured out what you're doing, I'm fascinated by it, and look forward to learning a whole bunch about it and everything. And
so are we.
Thank you very much for letting us come.
I just
before you go, Bob, on this expungement issue, that's something that I'm very concerned about. I want to work with you.
Okay.
Why shouldn't we just automatically have a statute that expunges records if you're found innocent or not guilty? Why shouldn't we just clean the records up and expunge them?
Well, I don't have a good answer to tell you why we don't. What our records had been, what we were more concerned about, and one of the things that you're going to hear from the Georgia Bureau of Investigation is they are still working with records that aren't accurate, that they can't get contributing. And this happened a lot. I think I had people come in and say, Mr. Keller, I went for a job interview, and they told me that I had a record. And I said, well, do you have a record? Well, 20 years ago or 10 years ago, I wrote a bad check. And I went to the magistrate court, but I paid it off. And I said, well, give me permission. And I just did this. I said, give me permission to run your record. And I didn't charge him any money. Give me permission to run your record, and let me see what I got. Well, lo and behold, I'm sitting there, and I run their record, and it shows bad check. Nothing else. It shows arrest, bad check. There weren't even a record. There weren't records of it. So I would write a letter, trying to get the record even accurate. So if you're, we've talked about having accurate records, then we talk about, the situation of if they're found, they're found innocent. Now, I don't want to get into a situation if you're found innocent, are you really innocent?
Right.
That's an argument for another day, but it is an argument from an expungement. Should there ever be a record of the fact that you actually were arrested and that you were tried? And should that record adequately reflect what happened? Not guilty. And does there need to be a record? Law enforcement might say we need to know a person that has been arrested like that, but does Bank of America need to know that for employment purposes? Does Bank of America need to know that for offering you a loan? Or is that something that, is it your individual thing versus that? And that's the reason you have not seen a statute, Representative Brooks, and you've been around a long time. That's the reason that statute has not just said if you're innocent, you're expunged, or if that charge is dismissed. It's time to revisit it, though. It is time to revisit it, especially on dismissals and things that don't even come to this. And right now the onus is on that person, And when we were working with juveniles, and we were trying to figure out what to do with juveniles after 3 years, they can, after they reach a certain age, things can be expunged. And the concern is, do they know how to do that? Do they know? No, and they don't. And the answer is they do not. That is correct. And then it can be, and depending on who does it and whether you've got $25, and that should be something that that is something from a societal standpoint that we need to address.
Let me just give you one case. There's a young man who's in law enforcement from my home area,
Mm-hmm.
and he had a misdemeanor conviction a long time ago. He was a young man. He was a deputy sheriff. He wanted to apply for a low position. When he made application, he had to say that he had a misdemeanor, and he wanted to know what he could do. We actually had to get the DA in the circuit to work with him to get a private law. Take this case back before the judge in Wilkes County, the third case on this misdemeanor. And the judge had to sign an order in order to expose his record, to get that off his record in order to get another job. So a lot of persons, if you want to come into law enforcement, and who want to move to another jurisdiction, they have this issue of clearing their records to move on. And so this is fun. It's really something that we really need to do. It's affecting a lot of people.
It does, and the other thing about it is, you're lucky in a rural area that you still got the same, you've got some history, so that same judge will do it. You've got a situation in the more the metro area where judges change, prosecutors change, and I don't know what happened. I'm not about to touch this because, man, that happened before my time, and I'm not going to do it.
Actually, the same expungement procedure is pretty uniform across all jurisdictions. And that makes me think there's probably some sort of legal reason to do it that way. It's something that would definitely be worth researching. But like I'm just saying, everybody, uses the same procedures. So
It is. We've got one right now, and there's this kid can't get a good job, and yeah, you also at 59 you do things, and so I called an attorney. I said, you are going to represent this guy. Well, am I going to charge him, Bob? No, you're not going to charge him. Well, why should I do this? Well, because I asked you to, and he's going to take care of it, and he's going to walk him through it. And it's just some kid that just deserves a break. And you just thank you again. Based on we talked about, you had one of your members couldn't be there. I've got a doctor's appointment at 12:30 that I've got to take care of. So yeah, it is. I'm fine, but I just wanted to tell you I'm not going to be here with you this afternoon. But thank you again for letting us come.
If you have some more questions, you can ask me.
Yeah, but anyway, we'll. Oh, what time is it now? Oh, I'm fine. I can get there. They're not going to be on time. But I'm gonna leave. I want to wait. I might leave closer to about 4 to 10 or 10 to do it. Sure.
Cooper, did you have any questions?
Oh, sure. Oh, you want me to sit here? Oh, I thought you had somebody else here. No, that's fine.
No. I want to understand, and I think we've addressed the DNA thing fairly well, just for the edification of the committee, to kind of put in context. We talked about certain things that are procedural, and then certain things that are collected based on probable cause that are more evidentiary. Procedurally, for misdemeanor arrests, when you're going to actually book someone, or a felony arrest, is there any difference in what's collected from people and what is typically collected? I mean, typically we see, against, the mugshot and the fingerprint. What is typically collected in those in arrest and as you kind of move through the system, just to kind of provide a context?
Let's forget the crime. Let's just say misdemeanor, or you're being booked into the jail and you're going to have to bond out. You're going to have to go through it. They're going to take your fingerprints. They're going to take your mugshot, and that's going to be it. They're right now. They're not taking DNA. They're not taking anything else from the standpoint of that. Now, any other evidence collection is going to be doing pursuant to either consent as it relates to something that was, if you were, that was part of your arrest prior to even getting to the jail, like searching your car. If they're going to take hair, are they going to take blood? Are they going to take, now we won't get into the implied consent as far as the driving, but if they want to take something for the investigation of the crime on a felony arrest, they're either going to have your consent or they're going to have a search warrant.
And that's clearly established, no questions.
That is clearly established. But now, if you're being arrested and booked into the jail, they're going to take your fingerprint, they're going to take your mugshot, whether you're a felon or whether you're a misdemeanor.
Well, philosophically, you can get at, is that because they're just trying to identify you? And it's more of an identification thing than an evidentiary thing. It is an identification issue to make sure you are who you are. Now, the other thing that happens, too, is when they identify you, there's also a situation that, depending on who you are, there might be a bench warrant out for your arrest. There might be another warrant from another state, another county, showing that you escaped from or that you're being wanted. And so that identification then puts you in a position then to be exposed to something else if you have, if you've been accused of that. But it's strictly it is strictly to make sure that that if you say, I am Robert E. Keller, that you are in fact based on the fingerprint identification, and that now they'll ask your social security number, which will also help them. Your date of birth, the date of birth, social security number, photograph, fingerprint. And again, that is an identification thing. We understand being able to run cross checks, and I think everyone understands the importance of that. The question is, although that's the fingerprint and the photo are collected for identification purposes, that fingerprint then can be run can be cross-checked to see if those prints get a hit on some other crime scene. So and that same fingerprint collected pre-probable cause, but for purposes of identification, can still be used in an evidential way in the same case or in some other case, can it not?
Well, evidentially, that fingerprint could be used to show that the person we booked in owned that fingerprint. And so if there are fingerprints that are collected at the scene of a crime, those fingerprints can be compared to what we call the known fingerprint. The known fingerprint of Robert E. Keller, when he was booked into jail, is compared to these 4 fingerprints that were left at a particular scene of crime, and therefore it would be used. That's the evidentiary way that it would be used.
Okay, so the discussion is, and I think this is something we need to, it's a policy decision we need to get our mind around, which seems to be, I'm making some assumptions, it seems to be where California's going is they're taking the DNA to say this is just a more certain way of identifying you. It's a 21st century fingerprint, as it were. But again, that can also be run and cross-check against other crimes and make that link. So it's being done now with a fingerprint. The question is, from a policy standpoint, although it's not collected in the context of probable cause, it's an identification thing, it can still be used in a way that, in effect, can tie you to other crimes. That's the policy thing I think we've got to deal with. But I wanted to make sure it's just limited to photo fingerprint now. Right. And hair, blood, urine, any of those things are pure probable cause driven.
Probable cause driven.
Okay.
I think following with that is the way that these other states are going and the current problems we have with our expungement, then we might be treading on dangerous territory. If we had our expungement laws to where if we were brought in for questioning, let go, obviously you had nothing to do with your innocent bystander, and we knew our records were going to be expunged at that might be an area that we look at expanding into. Okay, do you take an identification of someone on a misdemeanor? But I'm afraid to kind of tread into expanding what we're doing right now. Learning what I have learned today dealing with expungement is that that's going to be on record forever unless I just happen to know that I need to go ask for it to be taken off. If I do, let's say I was at any point from the arrest on found innocent either through lack of evidence or absolutely cleared through the evidence or up to a jury saying I'm innocent, and I request records to be expunged, is there any reason that my request is denied, or will that have to be expunged upon my request?
If your jury finds you not guilty,
Right.
no, you cannot. The statute does not provide for an expungement in that situation.
Other than that, if I request to be expunged, do they have to expunge?
Up to a point, you can.
Okay.
And we've done it. Now, here again, you have to request it, but the case comes in to the district attorney's office, and the case that we're talking about right now is a murder case. The case that I'm trying to help this
Right.
young man on is a murder case where he was charged with the offense of murder, and it never went anywhere. It never was indicted. The district attorney's office said there was insufficient evidence to prosecute.
Right.
But it was not expunged, in the sense of taking care of it. And so the onus is on him. Now, if he had already gotten to an indictment situation, then you're talking about a different situation.
Does the expungement also go as far as not? I'm thinking of this as a record. In the scenarios we talked about, where just brought in, questioned, and DNA fingerprint is taken, those records are kept.
Well,
or that information, or is it just used to identify me and there's no record kept at all?
No, it's no record kept. I mean, that's the thing. If you're just brought in and in your scenario where 6 people go to the police station, 2 of them end up going to jail, 4 of them go home. The 4 that go home, other than asking you who you are, and for identification, making sure that I call you the right name when I'm correct, there's not going to be any retention of that.
So
none of that. I mean, you're not going to be talking. You're not going to be fingerprinted. You're not going to have now. What Ms. Kimbrough was talking about, if it was a gang situation, they might take your photograph and keep it in a little thing, but they're not going to keep anything. They're not going to have. You're not going to have any other record.
I just wanted to clarify that when we're talking about taking fingerprints and taking DNA samples, what we really need to keep an eye on is like constitutional protections and whether the obtaining of this evidence satisfied constitutional requirements. Like when they take your fingerprint, did they have probable cause to take it and satisfy the 4th Amendment? Well, okay, yes, they did. Then they have a right to have access to your fingerprint. And I also wanted to clarify, since we've been talking about all this stuff about DNA samples taken upon arrest and stuff, I just wanted to clarify that in Georgia, the no sample goes into the DNA database until after conviction. So that means we satisfy, before you end up in there, we satisfy not only the 4th Amendment, 5th Amendment, the 6th Amendment, 14th Amendment, like any constitutional amendment that must be, complied with to get a criminal conviction. And a criminal conviction is the strongest statement of guilt that is available in the law, and we required that before we'll put anyone's information in our DNA database. And that actually goes beyond what is required by the Constitution. So I just wanted to point that out.
One quick question: is DNA information ever collected? I know it sounds silly, but for misdemeanor to prove someone shoplifted or
if you got it. Now, I mean, here again, if there is a way of DNA,
simple battery or something like that.
You could. Now, here again, it's a balancing. I mean, you've got a situation like you do a lot of times in the prosecution of a case. The Georgia Crime Lab is woefully understaffed when it comes to how they can do things, and as efficient as they are and as effective as they try to be. If I sent DNA on a shoplifting case, I don't even want to. I won't look at them right now. Okay, I refuse. But the answer would be if you obviously if you could, anything that will remove a doubt in a juror's mind, you want to do that from a prosecution standpoint.
But legally, and again, I don't have the code in front of me. I don't know if simple battery is a misdemeanor.
It's a misdemeanor.
But in the case of a domestic violence or simple battery or something, if there's hair or something they collected and they wanted to prove it, and for whatever reason they ran it and proved it on me, upon conviction that would then go to the GBI crime lab.
No. Upon conviction, you would. It's a misdemeanor.
Okay.
You would not see. You gave up the DNA that was used for your conviction was gotten one of two ways.
Okay.
Either there was something left at the crime scene,
Okay.
and then based on that, we then got your DNA through a constitutional allowable way. You either consented, or we used a search warrant to get DNA, and we compared your known DNA with what we had at the crime scene. That is the only DNA. That DNA right then is evidence that is kept, depending on the retention of after so many years. That evidence would be destroyed after your conviction. Now, once you are sentenced, because it's a misdemeanor, there will be no subsequent DNA collection for our DNA base, even if you are sentenced to jail.
I understand that.
Because it's a misdemeanor.
But the DNA that's collected as evidence in a case upon conviction, let's take a felony case. The DNA that's collected to get a conviction, once the conviction is consummated and complete, and say I'm convicted, that then goes into the
There is
database
and Amy Mike can help me on this. There is a retention of DNA evidence after conviction, and I don't know how long it is. I don't know whether I don't know whether it depends on it. It either depends on the crime or it's a certain set year, and it might be 10 years, and I don't know what. But there is Amy, isn't it? 10. Okay, 10 years.
Okay.
Is it automatically destroyed after 10 years?
It can be destroyed after 10 years.
Can be.
It can be
usually
destroyed.
It's not.
No, it's not. Normally, here again, especially in a death penalty case or something like that, you're just not going to do something.
This is only upon conviction.
This is 10 years after conviction. Yeah.
I mean, at that point, they've lost their constitutional rights.
My concern is that if in the course of a misdemeanor case, and it may be a misdemeanor of high and aggravated nature or whatever, that if DNA were collected, that upon conviction, it's a policy discussion whether that should go and be maintained long term. Maybe it should be, maybe it shouldn't be. But that's a policy discussion I think we need to have. I think there's a pretty strong precedent for maintaining that for felonies, particularly violent felonies.
Yep.
There's no question about that. I think it'll be a policy discussion for us on the misdemeanor side. I don't know that it's a big deal, but I want to just try and understand where we are.
Yeah, and misdemeanors, it would be retained, but it wouldn't be retained in the database and compared to other samples.
The sample would be retained, but it wouldn't be
just in case you
It's
need
a
to
different-
retest it, but it would not be like in the database that can be run against all these other samples.
Okay, so understand. Gotcha. That being said, thank you so much for coming.
Thank you very much. And,
really appreciate your.
I now am at the point where I think the doctor's calling.
Make sure that doctor doesn't release any of those records.
He won't release any.
I've
still got a badge, and he doesn't know.
Oh, okay.
I've got 11:46. If it's the pleasure of the committee, can we take a 10-minute break and get back in here at get lunch ready? We've got. Are we ready? Have lunch? We had lunch on the schedule at 12:30. Do you want to come back at 12 and start that, or would you rather just hold off on 12? Okay. We'll be back here at 12 o'clock. There's box lunches for folks, so Jennifer, our assistant, will help get those out to folks. Let's take a 10-minute break.